All right, welcome everyone. Good morning, good evening, and I think it's some places it's late evening. So we are uh, getting started in about 30 seconds. We are very happy to have Dr. Aeraj Haque with us. Dr. Aeraj is a patent attorney at one of the leading firms in Chicago. Before I get into his introduction, let me introduce the platform. We are STEMatters. STEMatters is a nonprofit registered in state of Texas. We formed STEMatters to inspire students from all ranks to excel in science, technology, engineering, environment matters, and mathematics. So we nurture critical and analytical thinking skills by engaging, guiding, and enabling students who worldwide to innovate, invent, and deliver quality solutions to challenges of our times. So we develop many research and educational programs to provide local, regional, national, and global activities to learn, collaborate, and possibly compete for excellent outcomes. Many people inspire us, like Dr. Aeraj Haque himself. Scientists, engineers, doctors, educators, and researchers who have accomplished amazing goals in their own career. So these outreach and engagement programs are possibly helping us to engage many more people. There are many volunteers who work with us from around the world as well. If you are interested in learning more, I request you to engage in these channels. We have a YouTube channel where if you subscribe and like, you can get feed as more programs become available. I'll share this information in the chat in a few moments. So now our speaker, Dr. Aeraj, he has many different dimensions to personality. He's a PhD, master's and PhD from Purdue University, one of the top universities. I think Purdue was second or third this year in engineering in the whole USA. He's based in Chicago. He has interdisciplinary background in mechanical engineering, agricultural engineering, and biological engineering. He even got Purdue Student Engineering Foundation Outstanding Graduate Student Award during his studies for his work with NASA on microgravity. And I hope he'll talk a little bit about that, because that was an amazing work. And we were there and we are very proud of him when he did that. So as a patent agent, patent attorney, his practice area is in many different engineering and scientific fields. For example, he works in biomedical, medical, diagnostic devices, agriculture technology, biosensors, nanotechnology, microfluidics, battery technology, automotive technology, and some of his clients, he has huge clients, Cummings, University of California. I don't think we are at liberty to talk about many of his clients, but I'll let him take it from here. Dr. Haque, if you would like to share your screen, please go ahead, and the floor is yours.
Thank you so much, Samir Bhai, for that introduction. As you were talking, introducing me, I was like, who's this guy talking about? Oh, it's me. Okay. So thank you guys for stopping by to hear, to spend an hour listening to me. I hope you'll enjoy the talk, and you'll hopefully learn something about patent law from this one. So I'm going to talk about science to law. But before that, I'm going to just give a brief introduction of my own. How did I get over here? A lot of you guys, I understand, are based out of Lum. Some of you might be here in the US. I started my educational career. I'm born and bred Karachi. I grew up in Karachi. I went to Springfield School over there. Wanted to do engineering. Ended up at NAD University of engineering in Karachi. Did my undergrad in mechanical engineering over there. I think that was the best time of my life. The 4 years of mechanical engineering at NAD is perhaps the funnest thing I've ever done, and the great friends we make over there. So from there on, I wanted to pursue higher education in the US. I was lucky and very fortunate to get admitted to Purdue University, where Samir Bhai was one of our seniors, and even my lab mate at one point in time. I did my master's in mechanical engineering from Purdue. Most of my research at that time was focused on nanotechnology and its applications to biological sciences. I was doing mechanical engineering. I was very lucky towards the end of my master's. I got a chance to work for NASA on a particular, technology that we wanted to develop to see how plants behave in a microgravity environment. And, I consider, I think the best experience of my life is I got a chance to flow in the NASA zero gravity flight, what we call the Vomit Comet. That was, I think, pretty much a life-changing experience for me. That picture of me upside down is not actually upside down. That's me floating upside down inside the NASA Vomit Comet. Our experiments were automated, so we would just click a button, and for the rest of the flight, we just would, try to do different maneuvers and enjoy the zero gravity experience. So that was such a motivating experience that I decided I wanted to, prolong this and do a PhD. So I transferred over to the Department of Agricultural and Biological Engineering at Purdue. AB department is pretty much the number one department in the Purdue AB department is number one biological engineering department in the US. I think it still is. So my research during that time was again focused on developing micro and nanotechnologies for fundamental biological research. I think, on the right, what you see are microsatellites that, our experiments would run on. So these would be small satellites that you would launch in space and that would perform experiments autonomously. That was a great experience. After my PhD at Purdue, I got a fellowship as a postdoctoral fellowship at Argonne National Laboratory. This is a Department of Energy laboratory, which does a lot of fundamental science research. So I joined there. I continued to work on, a new kind of biosensors, biochips for biomedical diagnostics and sensing and other features. I think my crowning glory at Argonne was I was perhaps the first postdoc who founded a startup. Always wanted to be an entrepreneur. I got that opportunity at Argonne. So I launched a startup for veterinary diagnostic applications. Basically, the idea was, to predict what kind of diseases cows have, which decreases the quality of the milk, and to be able to administer, a therapy much faster. It's a $10 billion global market. So worked with this startup for about a year while doing my postdoc. At that point in time, I kind of realized that I really don't want to do hands-on research anymore. I wanted to pursue a career which was kind of on the cusp of business and science, where I could, more towards the applied side of science. So I looked at different areas and then eventually ended up pursuing patent law. A lot of people whom you might not know what patent law is all about. It's about, protecting inventions in very crude terms, protecting inventions which are mostly coming out of some kind of technological innovation. So at least in the US, all patent professionals have a science or an engineering background. So it was a logical step forward for me. So currently I work at a large law firm. It's a general purpose law firm based out of Milwaukee, but we have offices in 25 cities in the US, as well as international offices. I'm a senior patent agent and patent law clerk. So the clerk part comes in because basically I'm a patent attorney in training. I'm about 3 years into law school, I'll be finishing pretty soon at Loyola University, Chicago. My clients that I represent are pretty varying. I work with Fortune 500 companies. Some of my clients are listed over here. I have many more clients. I think the most fun I have, though, is working with startups. who are coming up with new technologies and helping them develop their patent portfolio from the beginning, I think is the most rewarding experience for me. So what's intellectual property? So intellectual property, it's similar to actual property. You have property, you own, this is your house, these are my boundaries. Intellectual property is similar, just it's intangible. It's basically an idea that you want to protect. That idea has a boundary. What are the metes and bounds of your idea that nobody else has already done, or we cannot fathom from things previously done? That would be your intellectual property that you can be awarded. The idea behind intellectual property, in the US at least, we realize in this economy, we want to reward inventors by giving them certain rights over the new intellectual creation. So what's the reward? If you are a student, you come up with a new idea, and you think this is the next great big thing. And then you talk about it, next thing you know, everybody else is copying and using it, and suddenly you have no right to it. Intellectual property protection gives you the right to protect that idea so nobody else can do it without your permission. The idea is, if you don't do that, what's the monetary benefit that you are rewarding inventors? As much as we would like to believe in a social justice mission, eventually money drives our economy. So if there's no real monetary motivation for you to make an invention, how long can you go, keep making new inventions, or what would be the motivating factor for innovators? So that intellectual property protection gives you is a way to reward innovators to continue innovating by at least giving them protection over their property. Again, it provides opportunity to obtain monetary benefit. If you own the intellectual property, you can license it, you can sell it, you can monetize it. But intellectual property protection, there's various forms of intellectual property. And the first form is trade secret. This provides protection from valuable business information. Basically, a trade secret is something that you come up with a new invention, new formula, something new that you think, would be very easily copied, so you don't want to share it. The benefit is, till that idea remains a secret, if somebody tries to steal it from you or benefit in some other way, unless you yourself disclose it, you can actually assert it in a court of law. So some examples of trade secrets are the Google algorithm, still a trade secret. The Coca-Cola formula, apparently the formula for Coca-Cola is kept in a vault beneath the Coca-Cola headquarters and has been there for I don't know, maybe more than 100 years. And it's being protected. Very few people have access to it. The WD-40 formula, I think that's no longer a trade secret, but used to be. I don't know if WD-40 is available in Pakistan, but it's like, some people even believe it can cure backache. I don't know. It's basically a degreaser. And then Listerine coolant. Now, Listerine is an interesting example. Pfizer, the company which developed Listerine, had the formula of Listerine was trade secret. Pfizer eventually bought the rights to this and kept paying royalties for the formula. The formula eventually became public. And Pfizer, public information. Once it's public information, it's no longer a trade secret, because everybody knows it. Pfizer eventually had to sue the original inventors, that they're not going to pay them any royalties anymore because the formula no longer is a trade secret. So you can see the monetary benefit of it. If you can maintain something as a trade secret and just you can actually be monetized indefinitely. As long as you can maintain a trade secret. As soon as you lose trade secret protection, then it's public information, anybody can use it, and you don't have any right to it. So that's the drawback of having a trade secret. Once it's public information, no more money making off it. Copyright is the second prong of intellectual property. So that protects original artistic work that is fixed in a medium. So the term is 70 years from death of author. So if somebody wrote a novel, J.K. Rowling wrote Harry Potter, 70 years from the death of J.K. Rowling, she would still have copyright if she's the current copyright owner, whoever is. So, the Harry Potter, of course, everything related to Harry Potter, the artwork, maybe even the facial likeness of characters, that might also be copyrighted. You can't just draw Emma Watson's likeness somewhere and then start selling it without giving her some royalty. The Statue of Liberty in New York, that was patented by Frederick Bartholdi in 1876. That's no longer under copyright now. I think it's been dead for a long time. So anyways, that's the second form of protection. Copyright protection is actually one form of protection that's very aggressively asserted in Pakistan these days. I mean, I know a lot of you folks watch Hum TV and Geo and ARY and all the dramas. A lot of these dramas end up on YouTube. So you will see recently that maybe a couple of years ago, you could easily get every single drama on YouTube. Now it's not that easy to get because I think the Pakistani media now is broadcast over here through official channels. I mean, you can actually subscribe. So they have an interest in getting people to actually watch it. So either the media outlets themselves or the companies that broadcast those channels in the US are asserting that right quite often on YouTube and other streaming platforms. So that's one area where I think Pakistan is doing well. Trademark, this protects words, symbols, etc. associated with a particular product. The term of this is how long you can maintain something as a trademark is still the mark remains in commerce. That means as long as it's actually being used to generate money or being associated with the product which is selling. So these are, I think this is the easiest to recognize. You see trademarks every single day as you're walking around. One thing to note is in trademarks is the trademarks should not become so associated with the product that the word itself becomes a name for the product. As long as the trademark is, when a common personal of ordinary, reasonable person sees this, he thinks of that as belonging to the company. That's how long a trademark can remain active. But think about the thermos trademark. Thermos used to be a trademark, but it became so commonly used that now, we call a container which keeps everything warm or cold a thermos. So the bottle is now called thermos. So basically the company Thermos lost rights to that trademark because now it's being associated with the product. It's become so diluted that, another one is Kleenex. Kleenex, everybody thinks of Kleenex as tissue. Kleenex is a company that made tissue, but because people are now associating with the product rather than the company, it's lost its trademark protection. Another example would be Velcro. I think the original name for Velcro was Loopsy Doopsy or some that kind of funny name. But Velcro, again, has become associated with the product rather than the company that made Velcro. Final one would be Xerox. Xerox they still have the trademark for Xerox, which is the company Xerox. But in the US, a lot of people now call photocopy Xeroxes. So they send a PSA with their products that please don't call the photocopy Xeroxes, because eventually if that continues to go on, they might actually lose trademark protection for the term Xerox. Finally, moving on to patent protection. So a patent protects new inventions or designs. One thing to note here is term of a patent. So when I talk about patents here, I'm going to be talking about US patents. Do note that there's 80% of what I say generally should apply to patents all over the world. I mean, different countries have different procedures, different formalities, a little bit different terms, but overall, the core concepts of what a patent is applies universally to most countries. I think it's the same thing for Pakistan. I mean, we'll talk a little bit more. I don't know if I talk about the PCT, but I'll try to loop that conversation in. So a term of a patent is 20 years from first filing date. This is a US patent. For a utility patent, which is actually an invention, something you basically invented. For a design patent, it's 15 years from issue date. So a utility patent is 20 years. For a design patent, is 15 years. We'll talk about what the difference between the two is. Do note that there is a finite time scale for how long the patent is active. once the 20 years from the first filing date, once that 20 years are done, then the patent becomes public property. So now anybody is free to use that. One area where that you might be more familiar with is generic drugs. So generally, generic drugs come on the market, unless, in Pakistan, a lot of drugs come from India, which might have different laws on how if they even allow intellectual property protection for drugs. But in the US, if a drug for the first 20 years, drug companies over here sell drugs for exorbitant prices. As soon as it comes off patent, then you'll have companies all over the world making that, and suddenly the price drops to from maybe $200 for a pill pack to maybe $20 a pill pack. So that's, if you go back to trade secret or copyrights, you'll know, or even trademarks, that the protection for them is a lot longer. So particularly in deciding to patent something or keeping it a trade secret has to be a business decision. So you should know how your intellectual property protection, the amount of money you're going to be spending on that, ties in with your business goals. Because if it doesn't, you might end up spending millions of dollars each year on IP protection that is really of no worth to you. So what is patentable? In the US, anything human made, even if it's a living thing, can be patented. So you can patent you can patent a process, a machine, a manufacturer, a composition of matter. You can also patent a new bacteria if you recombinantly synthesized DNA and then created a new organism from that. You can potentially patent that. What you cannot patent is an abstract idea, a law of nature, or natural phenomena. So you can't patent gravity. For example, you can't patent like Pythagorean theorem or some other new theorem you came up with. That's what we also call abstract. You can't patent the speed of light. However, you can patent the implementation of an algorithm on a computer system if it adds something new to what's already known out there. But generally, most things are come under the patentability domain. So let's start with design patents. Design patents protect just the ornamental design of a product, cannot protect something that is functional. So for example, the Apple iPhone, the original design for the iPhone, would be covered by a design patent. So generally a design patent is very simple. You have maybe 5, 6, or 7 views of the product, just showing the aesthetics of that product. So basically, aesthetically, an iPhone looks like this. Design patents came in the forefront a few years ago, maybe 5 or 6 years ago, when this original Samsung Galaxy phones came out. Apple was able to assert that the way those phones were designed, they were copying Apple's design to the point that it would confuse people between whether they had a Samsung or an Apple phone. So, and Apple actually ended up winning like a $1.5 billion lawsuit against Samsung, and it's still going on. And there's a lot of movement in that lawsuit, and that has proceeded. But you can imagine that basically, simply, if you can protect the design of something, it gives it's another aspect for your creative aesthetic creativity to give you protection for that. So for example, if you made a new statue and you just want to protect the statics of the statue, you can do it through copyright protection, but you can also do it through design patent protection. So you can basically protect one single thing through multiple intellectual property protection opportunities that might be available to you. Utility patent, this is what most people understand as being patents. So in the United States, a patent is a limited grant from the US government to an inventor, giving the right to exclude others from making, using, offering for sale, or selling the patented invention in the US, or importing patented invention into the US. Point to note over here, it doesn't give you the right to do it. It gives you the right to exclude others from doing it. You might own a patent to something, but you still might not have the right to do it, because performing a patent might need to license something else from somebody else to actually make a patent effective. But it does give you the right to exclude others from making, using, offering for sale, or selling the patent invention. The quite broad protection that way. Again, it's not a right to use the invention. It is a right to exclude others from using it. Two kind of patents. One is a provisional patent. Basically, if you come up with a cool idea, you're working in a field that's highly active. You're coming up with a new, technology to call cars. You're coming up with a new Uber Kareem competitor, and basically you have a new algorithm which you think Kareem is not using that will help you more efficiently direct the correct driver to a customer's home. It's a highly contested field. You want to file a patent on it, but the idea is pretty much half-baked. You also know Kareem is also pretty active in that space, and they are going to file they might file a patent any day. What do? The idea is not fully fleshed out. So what you do is then file a provisional patent. Most countries have some form of a provisional patent protection available. I'm not sure about Pakistan, but potentially you can file there might be an opportunity to file a provisional patent in Pakistan. But in the US, you can file a provisional patent. It's not reviewed or anything. A provisional patent can simply be a presentation or a one-page document, or maybe a couple of lines, whatever you want, however detail you want to put in it. And a cover sheet which includes basically your biographical information, and you file it with the USPTO. Nobody reviews it. It just sits there, but it gives you a date the date of filing is called the priority date. It gives you that date before which everything can be used against you as a reference to disregard or discredit the invention that you file. So the day you file the provisional patent, you have 1 year from that date to file a full patent if you want to maintain the benefit of the earlier filing date. So the benefit of this is this, that if you file a provisional patent, if you waited a year to file a full patent, now everything that has been developed within that year can be used against you. But if you file the provisional patent now and file a utility patent 1 year within that 1 year period, the first date is the date before which everything can be used against you. Do you have a question, Samir, Brian, this?
Yeah, so there are a few questions in the chat. I don't know.
I'm not seeing the chat. I'm so sorry.
No, it's okay. I can share those with you.
I think it might be a better option if we wait till the end for questions. That way I can just, address them. And those questions don't need to be purely intellectual property specific. You can ask me about myself or other questions you might have about, anything related to US patent protection, anything you want to talk about really, other than Hum TV dramas. I'm not up to date on some of them I watch, but, we can talk about. Okay. So Samir Bhai is an avid follower though, so he'll be a better avenue for those. Okay. So utility non-provisional patent is what we call a full patent. That is the patent which will actually be examined by the USPTO. Same would be the case with most other patent offices which allow provisional patent filings. This is what a patent looks like in the US, at least. Other countries, maybe some different kind of formatting, but similar things. Some fun patents. Eddie Van Halen, the famous guitarist, had a patent for essentially it was this piece. It was a support which allowed him to play the guitar horizontally. People didn't know he had a patent on it. Michael Jackson's, tilt on the Smooth Criminal song, that was actually a patent. They had hook shoes which would hook to clips on the stage, which would allow him to do that stunt. So he wasn't magical. He wasn't defying gravity. He was basically using technology, a patented technology particularly. And then this one, I mean, these might not be allowed today, but some I would say, in plain Urdu Jidal, filed a patent on basically a method of exercising a cat using a laser light beam. So what this guy is really doing is pointing a laser light beam and making a cat jump, and he was able to get a patent around that. Different times, different days. I don't think so you can get a patent like that today. I think somebody also had a patent on how to make a baby swing on a swing set. So yeah, a lot was patentable, but things have changed. I mean, the US Patent Office is getting a little more stricter. Let's break down what a patent looks like. So this is the first page of a US patent. If you were to go on patents.google.com, That's a very good resource to look up patents. If anybody wants to do patent research to find out where to find, start from patents.google.com. So here you have, USPTO, Van Halen, that's the name of the first inventor. That's the name of the patent. Inventor was Eddie Van Halen. This is the his address, home address would be there. Application number is here. That's the essential serial number, and the filing date. The filing date is the filing date of that utility patent. Sometimes you'll also have a priority date. That priority date would refer back to maybe a provisional patent or some other earlier patent that this patent is claiming priority to. That means this patent is coming from a previously filed patent. The original date then becomes important for you again for citing prior art purposes. What we call, in patent lingo, we call references citing against you prior art. That's art which was then prior to your art. Background is like a journal paper. Any of the article sets the stage. Now, traditionally, a lot of law firms or patent practitioners would write a detailed background, something akin to what you would say a journal paper background. This is a legal section. Essentially, whatever you put in the background, you are implicitly accepting that this is background information for you. So we at my law firm are very, very careful about this thing. We try to limit what goes in the background. Generally, it's very, very limited. It's more to fulfill, legal obligations. Summary, it's, again, in a journal paper, that would be a brief description of your entire paper. In the patent case, it's more a brief description of the key features. Generally, what we do is just reword the independent claims of the invention in the summary section, and there's some legal reasons for it. No reason to go into details on that. Then you have drawings, figures. Not all patents would have drawings, figures, but generally mechanical style patents, electronic style patents, software patents. Mechanical patents is obvious. You will have figures of what the products are, what the key features are. You have to show them if you want to claim them. In electronics or software patents, you generally have flow charts. You have some block diagram of a computational system. A method flow chart is generally there. In chemical patents, you have chemical structures, which are shown in the patent. In genetic patents, you have gene sequences that are listed out at the end. Those can be very, very thick patents because there could be like 100 pages of gene sequences listed over there. So those are some of the key, figures that would go in there. Notice the numbers that are listed over here. In a mechanical style patent, generally what you want to do is label each thing that you will refer to. So maybe a forearm was labeled as 100. So every time you say forearm and you're referring to figure 1, you would recite the reference numeral 114. 114, maybe keys or whatever they're called. 112 might be an arm. 104 might be a base. In patent lingo, we tend to generalize the term to use. So if I don't know what a guitar bass and guitar, I'm not a guitarist, so I don't know what that would be called, but like we might call a base a substrate or something, might call legs projections or some other word to maybe generalize it and make it difficult for other people to search for it. But also to expand beyond the scope of what the inventor came up with. Detailed description section is where you describe in detail your invention. Generally, you should describe the invention in sufficient detail such that one of ordinary skill in the art could make and use the invention. The term one of ordinary skill in the art is kind of a legal term. It's legal standard of who is the person who would do it. So in the case of if you have a mechanical kind of invention, generally it could be like somebody who has a bachelor's degree in mechanical engineering with 1 or 2 years experience. But it could also be a diploma holder if he understands that. So that's a legal standard which is set based on circumstances. Should include what each inventor believes to be the best mode of practicing the invention. That's a US thing. It's subjective. What do you mean by best mode of practicing it? Basically, if you're going to be selling a drug, you might want to also have data showing the drug's efficacy for treating cancer to show that it's the best mode of practicing. If you're going to be developing an intravenous drug and you keep talking about oral, not talk about intravenous, that might be something held against you. It does not define the scope of the invention. The scope of the invention could be much broader, but does describe what your main invention really is. Scope of the patent is not limited to individual examples, features. Again, it could go beyond that. Now, the important thing is you can rarely add text post-filing. So you need to be very careful that you have included all that you needed to include in the patent filing. If you file a patent today and tomorrow you come to me, hey, Raj, remember the patent we filed yesterday? Well, there were a couple more figures that I got left behind. They were sitting on my desk. Can we file them today? Well, in the US, there is a way to file them, but the problem is they won't, they will extend it's called you'll most probably file a new application. And it might depend upon the examiner if they give you the right to the earlier date or not. Some examiners might not even give you the authority to file that. Generally, the thing to remember is whatever you filed on the date of filing of the application is the only thing you have to move forward on. If you found something new, the best idea is to file a new application. But if it's but then your own application might be used against your new filing. So be very careful when you're filing applications to ensure you have all the important things going in. Of course, it comes with a caveat that you have so much time. If there's an urgency to file the application, it's better to file it with the amount of information you have. That's where provisional filings might come in handy. But if you reach the filing date, there's a limit to how much you want to add. So if you file a provisional, the 1-year deadline is coming up. That's a legal deadline. If you don't want to lose your earlier priority date, go ahead with filing the application and then pray to Allah. So then again, this would be what detailed description would look like. You would describe particular features, putting in reference numerals as you refer to particular figures and things like that. This section is more like what you would think in a journal paper, though with a lot more legal lingo. Brief summary. Abstract is the last section. Again, different from an abstract of a journal paper. It's a brief summary. There's a word limit in the US. It's 150 pages. Most other countries have some word limit. So it's a pretty, I would say, if something we write very formally. Don't put in a lot of effort into this. The most important thing in a patent is the claims. That's true for every country in the world. Claims are what you're actually claiming to be your invention. And that's what I think patent attorneys get paid money for. We draft legal lingo to define what the invention really is. It can be an apparatus, such as a mousetrap, a method of manufacture. For example, a method of making a mousetrap. Can be a method of use, a method of setting a mousetrap. If you can come up with a new method of setting a mousetrap. Can be a composition of matter. For example, again, a composition of a drug, a new chemical. Can be a gene sequence. Independent claims are key. Independent claims are what you consider to be your broadest invention. And then you have dependent claims, which refer back to your independent claim and then narrow the invention so that if the broadest thing you're trying to claim turns out is already protected by somebody else, maybe you add something from the dependent claim into it to make it narrower, your scope. So think about you going to a farm and lay a perimeter around that farm. This is my property. Next thing you know, this new farmer comes and say, hey man, you are on my borderline. See my documents? I own this. Okay, I'm going to pull in my fence a little bit. Now this is my new property. Somebody else comes in. He's like, oh man, you are also infringing on the north side. So that's how you kind of keep shrinking it until you come to actually what the patent office considers new. But if you infringe one claim, somebody infringes one claim of your patent, they infringe the patent. So if somebody infringes your independent claim, they infringe your patent and you can sue them. So a pop quiz time, and don't feel pressured to answer it. I mean, this is such a fire hose kind of presentation that I don't expect somebody, you guys know the answer to this, but let's try it. So you have a patent, it claims a mousetrap comprising. Comprising means is legal language. Comprising means it gives you the option to have other things. So comprising means it includes, but it can also include other things. If you said consisting of, that would say that it only includes these things. It cannot include anything else. So language is very important. So you have a mousetrap which comprises a base, a coil spring, and a bar loaded by the coil spring. Then you have a product which is a mousetrap which has a beige colored base, a coil spring, and a bar loaded by the coil spring. But it also has a preloaded bait. So do you think product number one infringes claim number one? Anybody care to answer? And that's fine. I mean, don't feel pressured, anybody. I'll give you the answers here if I can remember them. Okay. So the product number one most probably infringes our claim number one. So product number one has a base. It is beige colored, but we don't say in our mousetrap, we just say a base. So it could be any color. So probably, this beige colored base is covered. Product has a coil spring. Our claim has a coil spring. So that is also the same. A bar loaded by the coil spring. We have a bar loaded by the coil spring. Now, the product also had a preloaded bait, but we don't exclude having a preloaded bait in there. Remember the comprising language. You could still have a preloaded bait in there. So most probably, product number one would be infringing patent claim number one. So product number two has a mousetrap having a base, a leaf spring, and a bar loaded by the leaf spring. Now, see, notice the difference over here. It's pretty similar to product number one, but you have a base. But instead of a coil spring, you have a leaf spring and a bar loaded by the leaf spring. Do you think product number two infringes patent claim number one? Let me see. I can see some chat. Yeah, Muhammad Ali Ahmed said no. And he's absolutely right, because you have a leaf spring while our claim talks about a coil spring. So product number two does not infringe. Let's go against to product number one. You have a mousetrap and the base is blue. In this case, product number one, the way you would read it is claim number one and patent claim two would be a mousetrap comprising a base, a coil spring, a bar loaded by the coil spring, wherein the base is blue. The way you read them together, if you think about a dependent claim. So in this case, again, in this case, maybe product number one does not infringe claim number two, but it doesn't really matter because it already infringes claim number one. And you just have to infringe one claim to be infringing a patent, and we can sue you and make the money. Let's move on. So in validity, patent validity is basically you file a patent, you got your patent. Now, is your patent actually valid? Basically, are the claims of your patent valid? In very simple terms, was this actually done before? Not what has this been patented before. So it doesn't matter if what you are patenting or have patented is been patented before or not, if anybody has done it before. So if anybody is, whatever has been done before is called prior art in legal lingo. So sources of prior art, what can be used against you are patents, patent applications, journal articles, ads, sales, public disclosures, demonstrations. This meeting, for example, if sitting over here, I spoke of some new invention to you guys, just, not realizing what I was saying about. And then my client is trying to file an application. Maybe in the US, he has a year to file it, but in some foreign countries, as soon as it's public disclosure, and this would be a public disclosure, then you can't really, it's not patentable because it's public disclosure. That is a very important point to note. A lot of the people here, I assume, are science, are students or professors or in the academic area. We go to scientific conferences, we teach in our classes. If you have a new idea that you are thinking of filing, you think could be patentable, do not talk about it in public to anybody. Maybe to your wife, if you have a wife or whatever, your spouse. That might be covered by spousal privilege, but beyond, or to your legal advisor, which might be covered by attorney-client privilege. But do not go talk to your class. Do not go present a journal paper. Oh, it's just a journal paper. I'm just going to show some. Maybe you can do it, but you need to make sure that what you're presenting is not enough to be considered a public disclosure of your core invention. The idea is to keep it secret, because the day it becomes public disclosure, in the US, you have within a 1-year grace period within which you can file a patent application on that. But you will rules most probably in Europe won't allow that. China won't allow that. I'm not sure what the rules in Pakistan or India are, but they might be similar. So very, very careful about, filing disclosing anything which you think is. So if you have something, talk to an attorney if you have one. If you're at an academic institution in the US, there are tech transfer offices and, where people go to with their new invention and they facilitate filing a patent. I'm not sure what the equivalent of that would be in Pakistan. If it's not, it would be to go to maybe a dean or somebody to talk to them about it. And if that's not the case, and if you have all rights to your invention, maybe talk to a patent attorney in Pakistan. Look them up. I mean, I did find some, but I don't have anybody on the top of my head right now. So patent and validity are two ways you can validate a patent, or your claim can be ruled as being not patentable. One would be anticipation. So if all features of a claim can be found in a single reference, it means that reference anticipates your claim, basically saying your claim is not novel because everything you're doing is already taught in something else. So if you made a new glass and somebody cites another glass, it's like, yes, there is a glass. All claims are taught in the glass. Obviousness is the more tricky one. Most of the features can be found in one or more references, and it would have been obvious to have all the features of a claim. So one patent teaches a bar stool, the other reference teaches a bench with a back, and you make a chair having 4 legs and a back. Then the examiner might say, well, you combine these two together, anybody can come up with a chair. And it's your job to convince why somebody will not be able to come up with it. And those are generally can be technical arguments or legal arguments, and or both. Again, the key date is your first application filing date. Remember that date, first application filing date. Before that, things are used against you as prior art, not after that filing date. Now, small quiz again, validity. You have a claim, which is a mousetrap comprising a base, a coil spring, and a bar loaded, the same, mousetrap company, bar loaded by the coil spring. Patent name, claim number 2 is the mousetrap of claim 1, when the base is beige. So there's a prior patent which discloses a mousetrap with a green base, a coil spring, and a bar loaded by the coil spring. So is our claim 1 invalid based on the prior art? Let me see in the chat. I see a no, but most probably it's a yes. So claim 1 would be most probably invalid. I mean, you have a prior art which teaches a base. Doesn't matter what color it is, but it does teach a base. It teaches a coil spring, and it teaches a bar loaded by the coil spring. Or we don't talk about a color in claim 1. So based on this, most probably, the examiner will give the deference that it's a base. And, you have these 3 elements, and you have these 3 elements in claim 1. So most probably claim 1 is invalid. But now you have claim 2, which says the mousetrap of claim 1 where the base is beige. Now, is claim 2 invalid over this prior art? I promise this is the last quiz.
Okay. I think so. Better number 1, sir.
Yeah, so, technically, you have a base which is beige. The prior art teaches a base which is green. So most probably it's not invalid. Claim 2 is fine. But the examiner will say it's obvious. Just changing the color, what's the big deal? You just change color. So it's most probably obvious over the prior art. But you can make a case it's not being obvious. For example, if the beige color attracts mice. So somehow or the other, you found that mice have infrared vision or something, and then the beige color attracts them more, which makes the mousetrap more functional. So the color is now a functional element of it, and the prior art discloses a green base, so then you might be okay. So you can include then claim 2 into claim 1, and that might get your patent allowed if you're able to make that case. Okay, so again, nuances. Final tips, to wrap it up, if you have a new idea, it might be patentable. Do not disclose it to anyone who is not an inventor. Now, who is an inventor? We didn't talk about it. Anybody who contributes to the conception of one of the claims of the patent is an inventor. This is very important to know for people who work in academia. When we publish journal papers, I remember when we were writing papers, we would be like, hey, friend, you edited the table for me. You edited the figures for me. Maybe you ran a couple of experiments. All of you become joint authors in the journal paper, and it's totally fine in journal publications. In a patent, this is a legal document. There is a particular meaning of an inventor. If somebody who helped you run all the experiments but did not contribute to any single claim, a claim could be anything simple. If, again, one of the persons said, hey, why don't we make the color beige, not blue? That's all he did. Did nothing else. And you claimed that, he could be an inventor. But if somebody just tested the mousetrap for you, nothing else, he will not be an inventor on the patent application. That's something to be careful of. If you have a new invention, document the idea, date, and sign it. That's your proof you were the first inventor. That used to be the case in the US, where it would really matter a lot. Things have changed in the US. Now it's first person to file with the new laws. So, you know, if you have an idea, it's all the more motivation to go and file it. Do a search for prior art. Some resources where you can search for reference for patents are patents.google.com, freepatentsonline.com. Use different keyword combinations. As I said, a lot of patent professionals, we will use language which is more generalized. So try using more general language. If you don't find anything within 2 to 4 hours of search, maybe there's something. I mean, you don't feel like you're compelled to spend a month searching. Spend a few hours on a new idea. If you can't find something, there might be a way. If you want to be really careful, maybe commission a search from some, with some prior art searcher. Thing to note is generally, if you discover something, you have to report it. It's your legal obligation to report it to the patent office that you're going to be filing the application with. In the US, we call it reporting an idea. So if you discover something and you realize this has an implication on your patentability, you need to report it to the US. That's a legal obligation. Again, once you have an idea, write up a basic description and sketch some figures. If money an issue, again, file a provisional patent. Those are a lot cheaper. In the US, if you're a single inventor, you might be able to file as a microentity. And that would maybe $75 or pretty compared to like $500 for a big utility patent filing, and save money to hire an attorney for utility application. That's the best way. Don't go on filing an application yourself. And that's it. One thing I didn't talk, I'm going to stop share unless somebody wants to go back to my presentation. And I'm going to move to gallery view so I can see you all. One thing I didn't talk about in this application was Pct Applications. That's Patent Cooperation Treaty Applications. So for example, you want to file an application that you want to file all over the world, but you're not sure which countries you want to file it. One thing you can do is file an application in your own country, and then within a year of filing that application, you can file a Pct application from that. A Pct application is basically gives you a right. It's called an international application. You file it with the International Bureau, and then 30 months from the first filing date, you have the opportunity to select countries you want to nationalize that Pct application in. So rather than individually filing applications in 30 countries, you can file one Pct application, and then maybe you realize, oh, England is a big market for me. I'm going to file in England. I'm going to file in the US. I'm going to maybe file in China. I'm going to forego India because I don't think so. That's a big market. I'm going to forego Spain and other countries. So a Pct gives you is a good a tool to file the application in multiple countries when you're not sure which countries you want to file in. And it also can save you a little bit of money rather than filing countries, because international patent filing can be very expensive. A lot of translation fees might be attached. You file a patent in China, everything has to be translated. You need to get local counsel over there in China to file that for you. Fortune 500 countries do it on regularly. But of course, sole inventors might be a tough deal. So you need to be careful where you want to decide. And that's it from me. Any questions? So I think there were some questions in the chat. I'm going to open it up now. Okay, so there was one question. Can some get permission to use copyrighted work? Yes. If you want to use copyrighted work, there are certain things, there's certain uses of copyright works that what we call fall under the fair use doctrine. Fair use, for example, if you're a teacher, right? You're teaching class, you want to use excerpts of a book to teach in your class. Most probably you're fine with it. So if you copy like one chapter, not the entire book, copy like a small piece chapter, you just distribute it to your own students for purposes of the class, you might be fine with doing that. Similarly, if you're making like, you copied maybe like you making a parody song, and you maybe copied a 2-minute clipping from a video, but basically mimicked, mocked it. Mockery or sarcasm about something is generally allowed in the fair use doctrine. Now, if you do something with a copyright product which defames the company, they might come after you for defamation or for diluting their copyright or their trademark. So that might be it. I see Sayed Ahmed's hand. So Ahmed, please go ahead, ask a question.
Sir, I'm audible?
Yes, absolutely.
Sir, I question that what is the differences between the superscript and the symbol, sir?
Superscript and symbol sign?
Yes.
In what context are you asking this question?
Copyright and trademark.
So I'm not sure I'm getting the symbol mark or superscript mark. Generally, if you're talking about the R, that generally means a registered trademark. If it is a C in a circle, that means copyrighted. We don't need to have copyrighted. Different countries, again, might have different laws. Sometimes you have to actually file a copyright protection, some kind of formal document with your local patent office. Sometimes you don't. But the C sign generally means copyrighted. R signs mean registered trademark.
And TM sign?
Trademark. TM sign is also used as a trademark. Some people use TM as superscript. You're right. Some people might use R in a circle. That means a registered trade. So TM might not be registered. It might be a trademark because they believe it's a trademark, but it might not be officially registered with the local patent and trademark office. So even if you haven't registered it, you still might have a right to enforce it.
Sir, I have another question about trademarks. How can I tell if my trademark is too similar to another person's mark, sir?
It's tough for you to tell it. It's basically a little bit subjective. So I think it's a reasonable person standard. If a reasonable person would look at your trademark and get confused by looking at the trademark and it represents something else, then it would be like, for example, Starbucks versus Starbucks. So Starbucks was sued by Starbucks, as far as I know. Now, if this is a false story, don't come after me. But this is what went into the, what I heard in the news. So Starbucks looks quite a lot like Starbucks, and you can see, the resemblance. So I think Starbucks sued Starbucks for the trademark. But Starbucks was able to make a case that this is the only original trademark because the grandfather was named Starbucks. That's the story, that they were able to prove it in court and Starbucks lost the trademark suit. But yeah, I mean, if you're able to prove it that you originally came up with it, you didn't copy somebody, you might have a case. Okay. Habil, you have a question.
Sorry, sir. Sir, my question is that what is the overlapping limit with other invention for filing a patent? I'm talking about an invention like you talked about algorithm of Karim or Uber. So there might be an overlapping limit, or is there no limit for
overlapping limit? Oh, I think what you mean by overlapping limit is in the legal lingo, it would be how close it can be to be non-obvious. That's for your, that's, I don't think so. If you have a new, thinking too much about whether there's how much overlap there is, will it be considered sufficient overlap to consider my invention invalid? Those are legal discussions which your attorney will have with the examiner, and those can change what the meaning of that is because it's very subjective. But there is a business reason for filing a patent application. For example, most applications, people think of invention as something unique somebody came up with out of the blue. That's not true. I would say 95%, if not more, of new inventions are inspirations. So for example, you saw a problem. You are closing a car door, it gets jammed somewhere or the other. You realize maybe I'll put in a rubber strip in there to prevent it from banging that way. I'll put a rubber strip so if I hit another car, my door is not damaged. The entire car is there, but you came up with the idea of a rubber strip, right? You didn't come up with the idea of the door which swings like that. You just came up with the idea of a rubber strip. That might be patentable, right? Similarly, if Karim has an algorithm, Uber has an algorithm, most probably it's not available to you. But even if you somehow or the other got that and you figured out a bug in it, Now, the algorithm itself, you won't claim that algorithm, like the entire, if that happens, then else. Generally, what you want to claim is the compact process flow. So for example, let's try to make a claim for a cab calling service, right? A computer system configured to receive instruction from a user corresponding to a cab ride. Then the second step would be, in response to receiving that instruction, search a database for available cabs. Third step, in response to finding 2 cabs within a 5-mile radius of said user, figure out, determine which has a better star rating, for example. And then based on that, assign the cab to a user, instruct the cab user to go to that particular ride. That's maybe, let's say, an algorithm I came up with. Now you figured out within that step to somehow improve the experience. I don't know how. Maybe you figured out, maybe if I add this to that algorithm, that will make the ride more efficient. Maybe, you figure out heuristics of the particular customer. That customer likes this particular driver, has driven within 2 times. If 2 drivers are available, but there's 1 driver who has been assigned to that customer 2 times before, maybe you assign that driver to that customer so he has repetition. So that's a new idea you come up with. Yeah, I mean, the examiner might say, but if Uber hadn't done it, nobody else has done it, your idea might be novel. Now, even if you don't get a patent, you file a patent, you start to prosecute it, Uber looks at it, Uber was thinking of the same thing, but then they realize, well, this guy's already filed a patent, it's pending, it's not granted yet, but there's some obstacle out there, and I want to implement it now. I mean, tech moves like really fast, right? So they might say, hey, Habil, or, we'll give you $50,000, sell it to us, give us the rights, and let's get done with this thing. Now you might get greedy. You might say, no, I'm going to get the patent. I want $1 million, not $50,000. Well, that's a business decision. But even just filing a patent might give you some leeway or leverage over a company in a hotly contested market. Okay. Habil, you have another question, or is your hand up from?
There's another question, which is, what's the cost, like optional fee of filing patent, and also normal lawyer's fee, US and global? I think you covered, but yeah.
So filing a patent in the US, I think if it's a corporate entity, a large company, those costs can be upward of $1,000. The filing fees, the administrative costs. Or maybe I think beyond $500. I don't know the exact. Again, my paralegals take care of all this formalities. They know a lot more about the actual numbers. But then you have a micro entity. So if you have a company which is maybe less than, maybe 75 people, something, there's a limit to it. It's considered a micro entity, and I think that filing fees is less than $500. But if you are, that's a small entity. If you have a micro entity like a sole inventor, like 3 inventors, and your combined household income is less than $180,000, or whatever number, maybe 180 for one person, or for a household $220,000, then you might be considered a micro entity, and I think you can file an application for about $175 to $200. So that, but then there are other fees you have to pay. You might have to pay for searching and stuff. So I think about $500, in the $300 to $500 range. Of course, I work for a large law firm. We charge about, for filing or for drafting an application, a full application, anywhere from $8,000 to $10,000, or even up higher. Some patents we charge about $15,000 to $20,000 per patent if it's a big one. Over the life of a patent, getting just one US patent allowed, you might end up charging you over the period of 2-3 years. You might end up paying anywhere from $25,000 to $30,000, if not more. Again, this varies from country to country. So if you're in Pakistan, the rate would be very different. That's in rupees. So I don't know, what the filing fees for Pakistan would be. There is a patent office in Pakistan. There are patent attorneys over there. And there are companies who do file patents. I think pharma companies over there file quite a bit of patents over there. So it might be worth reaching out to it. The important thing would be that for university students, your university, if it not, it should have some kind of a patent filing office that files patents for you, and the university might retain a right to it, but that's how most inventors in the US file patents. I mean, nobody has that kind of money, even if you are like a person like me, if I wanted to file a patent, I filed one of my own patents, but then I have the advantage of being able to do all the work myself. I can do all the legal work myself. But still, I mean, taking out $1,000 from your pocket is a sufficient amount, is a big amount. So I think universities should have such offices. And if they don't, maybe they should develop it. And that's something maybe you would want to talk to your deans or your VCs.
There's another question. So you were referring to not sharing ideas with your wife, spouse. So yeah,
No.
Interesting question. So your ideas, community property. So this related to more, I think, in US, where if there is a divorce, then everything is divided. So would patents be considered community property there?
So community property varies from state to state. So community property, I think California is a community property state, where basically the idea is that your joint income is considered the family income. Is basically both. In a state like Illinois, it's not. Don't think Illinois is a community property state. So unless you have a joint account, your wife's income is her income, your income is your income. Subject to state laws. And if somebody dies without a will, intestate dies, how does that property gets divided? Then there are state laws for it. Spouse gets 50% and other children and all that, so on and so forth. IP goes the same way. Intellectual property, unless, so again, there's an inventor and there's an assignee. The inventor is the person who invented the invention, and that's the name you see it. But there's another entity called assignee. Assignee is the actual owner of that invention. So if you died and you own the invention, so if you were just the inventor, there was no assignee. If there's no assignee, all inventors are owners, equal owners. There's no like 10%, 20%, 30%, unless you had a document supporting that. It's equal ownership. Then that patent, again, the rights for that patent might be divided between your wife and your kids if you die without leaving a will. But you can assign the rights to your wife while you're alive. So you can write in your will that all the rights to all my property, including my intellectual property, goes to my wife. And then she will be the owner of the patent. So in the case of universities, that's how it works. You come up with an invention, you come up during the course of your employment with the university, and then you disclose the invention to the university. The university will prosecute the invention for you. You will be the inventor, but the university will be the owner, will be the assignee. And then most probably you can get, if you launch a company on that, you can most probably license it back, hopefully get an exclusive license from the university to use that patent. And then it will be subject to royalties or whatever. That's how universities make money. I mean, if they're giving you all the labs, that's their return from it. Only difference is, I think, University of Wisconsin, I think they let the inventors own everything, but then they maybe don't pay for invention disclosure.
Right. So there's another question, which is that can patents get confiscated? So he's referring to Germany post World War II. So can they confiscate a patent?
Technically, I mean, what do you mean by confiscate? It's when a patent is filed, eventually it becomes public information. So 18 months, so when you file a US patent, 18 months from the filing of the utility patent, it publishes as a patent publication. Now everybody can see it, unless you file a non-publication request. But then if you file a non-publication request that comes with the caveats, now you can no longer file outside the US. So now if you file, let's say you file a patent on some superconductor, semiconductor technology, that, it got published, everybody knows it exists, but everybody also knows you own the patent. But then suddenly US goes into war with some country, you realize maybe we start running out of lithium.
So yeah, maybe it's more pertinent that can it be nationalized? Can a state... It can be.
Confiscated doesn't mean anything, but it can be nationalized. So it can come into the public domain. So there's national security reasons. The US government can confiscate your actual property. It can also, I would say, confiscate or nationalize your intellectual property. So, yeah.
Like, for example, there are export controls on many things that you cannot export that technology or that idea. So that's also where a state can restrict the use of that technology across certain borders.
Yes, so so they can actually restrict the maybe shipping or transportation to countries abroad. They can also, they most probably won't take your patent. What they will do is most probably automatically do a non-publication request, so your application will never be published. So nobody, you will get, if it's patentable, you'll get a patent, but nobody will the public will not be able to see it. So you have a patent, but you can't really, you can maybe enforce it in a court of law, but all the hearings will be very secretive and all that. And I think, maybe defense contractors maybe go through this. Now, what happened in Germany, I don't know. That's a totally different country, totally different sets of rules that applied in Germany. How different countries work, again, these laws also vary from country to country. For example, US may allow computer patents if you word it correctly. Some countries don't allow computer patents at all. India might not allow, for example, maybe drug patents are not allowed in some country. The US makes, drug companies thrive of their patents. And maybe India doesn't allow them. I'm not sure about them, but that allows India to make generics and sell them within India and other South Asian countries and make money off it. But they can't then sell it to the US where it's still patented. Okay.
Right. So, yeah, we have another question from Ahmed, Syed Ahmed.
Go ahead, Ahmed.
Sir, can a published research what be patent, sir?
Yeah, if you've already published a research, ideally you would want to file at least a provisional application before you publish your journal. Even if you've published it, you can, at least in the US, you can have 1 year to file a patent application on it. So you can do that. And that's what happens with most of our university clients and national lab clients, that they are writing a journal paper. And they're like, what, this is a patentable invention. They go talk to their tech transfer office and they agree that this might be worthy of filing a patent. So right before filing the journal paper, they would come to us, we would draft an application and file it for them, whether provisional or non-provisional. But even if they published a paper and then they realize, well, we could file, then we could most probably file a US patent within 1 year of that. And that's exactly how it works.
And sir, if I get a design patent, sir, what legal right do I have over that design, sir?
It's the same legal right that you have for a utility one. So nobody can copy your design, but then its design patents can be pretty narrow. So let's say, this is what I can see in front of me. So somebody, well, you can't really see it. So basically, no you can't see it. But if I had this iPhone, right? So the design for this iPhone, if I patented it all, basically nobody can copy something which has like a bezel, like a rounded curved surfaces, and a flat top like that. But then, if somebody else has some notch over it, which is a little different from what we have, maybe the feature of how the camera is located, maybe you can.
No, okay. There's no point.
So basically you can, if you can assert it, then it's a much more, I would say, intrusive experience, because then you have to collect data. Would people actually be confused by looking at your design and the design that you say infringes you? So design patents are important, maybe not as much as for you guys. I mean, maybe if it's an artist, maybe Gulji. If Gulji is making sculptures, Gulji's son makes sculptures, right? So he would have a copyright on it, and he would maybe have a design patent on it as well.
Sir, my last question.
Then one important thing with design patents, though, is the design can't be functional. If somebody can say, well, the reason you have a bezel is ergonomics, it should be purely aesthetics, no functional element to it.
Sir, my last question. Sir, USA always claim that, sir, Chinese companies, sir, steal our patents or sir, copyrights. Is it true, sir?
Can you repeat that question again?
We'll get into a little bit politics. So I think I'm sharing the LinkedIn profile for Dr. Rajul Haque in the chat. So please take it with him one-on-one on political questions. So I think we should stop here. I
just want to answer one question. There was a question about Habil. Can two people companies claim for a single patent for something like that? Yes. joint partners can be joint SNEs on patents.
So with this, I thank Dr. Rajulak for this amazing talk. And again, for everyone, this talk will be available on Facebook. There'll be a recording available on Facebook. It will be posted on our YouTube channel as well. And I'm sharing the link for the YouTube channel and other channels for us. And please feel free to subscribe, like, and be able to see more activities that come. So with this, I do virtual clapping for Aeraj. And I hope all of you have a good day, good evening. Thank you.
Thank you all.
Thank you, sir.